That members raised, I will accordingly put them in the order paper. So don't say your issues have been washed off. And last Thursday, when we sat in this house, we had a debate on the Copyright and Neighboring Rights Amendment Bill 2025. A debate was done. What was left was harmonization on matters that were contentious, and that was on section 9, clause 9 of the bill. This morning we had the harmonization meeting, and we accordingly harmonized, and we are ready to proceed to that effect. Honorable Lob, Thursday, maybe, not sure, maybe ED, and you're supposed to present the alternative policy statement. So in the circumstance that it may be a public holiday, what do we do? Can we agree that you will first send the report to the committee, then on the next sitting of Tuesday you'll formally lay for those members to start working? Honorable members, on rather sad note, one of us, Honorable Enos Asimwe of Kabula County, is currently nursing injuries sustained under very unfortunate incidents that happened last weekend. We keep praying for him for faster recovery, and may the good Lord heal him faster. Find time and check on a colleague. Once again, I want to welcome all of you for this sitting. And over the weekend, I had a lot of sentiments out there where people were calling us ignorant. We're ignorant, that's why we're not passing the law. One thing I want to tell the people who were sending messages, we are not ignorant. Whatever we did was for the good of the law. So if somebody is idle and starts sending messages that members are ignorant, please, we are not. Thank you. Yes, Lop.
Thank you, Right Honourable Speaker. Honourable Speaker, I want to join you. I've had you ask us to follow up on a colleague. It's very unfortunate what transpired. Maybe we'll reach out to him to understand the happenings around that and to commiserate with him. Honourable Speaker, you mentioned in your opening remarks, I came following, thanks to technology, that there is statements that have been deferred because these are issues that we had raised, and we were expecting the Minister for Kampala to talk to us about floods and the commitment by government to traders to compensate them, then Chitezi, the commitment by government to compensate those people, which has not happened yet. There was just a statement that we were expecting from the Minister for Justice about the biometric voter verification kits that we spent billions on, and they did not function. I didn't get you clearly, Right Honourable Speaker. Is it all those statements? Is it particular ones? Just so we can know what we are to anticipate, Right Honourable Speaker. And maybe now, and we'll keep loading government with more work because that's their responsibility anyway. As they prepare to bring through those statements, with your indulgence, Right Honourable Speaker, I think that the Minister for Justice, Minister for Internal Affairs, and the Attorney General should also help guide this House further. We make laws in this Parliament, Right Honourable Speaker, but many times these laws are flouted. Article 23 of our Constitution provides for protection of personal liberty. Article 24 of our Constitution, which was made here even before we did come, prohibits cruel and inhuman treatment, but we still see the same continue to happen, Right Honourable Speaker. The mode of arrest, what government calls arrest, which is kidnap, that continues to happen. We don't understand why these things keep happening. And Honourable Speaker, we will not stop to talk about them, especially here, because these laws are made here, and this is the space that we've got to use. Honourable Speaker, last week on Thursday, the home of the personal assistant to the Honourable Kyagulanyi Ssentamu was raided by UPDF officers. UPDF, because they were in uniform, and one of them identified himself with an ID as SFC. They were looking for this gentleman, it's called Naja Sheriff. They didn't find him there. I'm told they're also looking for the Honourable Kyagulanyi. Obviously, he was not there. And they picked up the wife to this gentleman called Natabi Fauzia. That was Thursday last week. The home was left abandoned, the little children, their mother was taken away. Up to now, Honourable Speaker, we don't know where this young lady is. This is wrong. You see, we keep telling government, if you are interested in anybody in this country, the law is at your expansive availability. Do summon people. But when you go and you pick up people, and you don't take them to gazetted detention facilities, it's a problem. And this cuts across. Honourable Speaker, we were here when one of our colleagues, the Honourable Paul Akamba, who belongs to the NRM, was equally abducted. And for days, his family didn't know, lawyers did not know. This is wrong. Forget that it is happening to NUP. It can happen to anybody else, like it happened to the Honourable Paul Akamba. So we must set these standards because the laws are passed here. If you're interested in somebody, summon them. When they fail to show up, I cannot defend, even as a lawyer, if somebody is summoned and they don't show up, I'll not defend somebody who is picked up when they were summoned and they didn't show up. Because if they summon you and you fail to show up, then they'll come for you somehow. But if somebody has not been summoned at all, you go and you pick them from their home. And for days, nobody knows where they are. Lawyers don't know where to start from. Family doesn't know. It is wrong. And we must stop this behavior, government. If you're interested in people, summon them properly so that they're able to show up. So I hope that the Minister for Internal Affairs, Justice, Attorney General can talk to us as Parliament. These laws, are they irrelevant? That the Constitution has been torpedoed, so it is that means even this Parliament is irrelevant. Because this Parliament passes laws. Finally, Right Honourable Speaker, this Parliament here appropriated money to the Electoral Commission for its operations for the just concluded election. We were here, we quarreled, and some of us opposed a number of the allocations, but the majority had the day. We have learned, Honourable Speaker, that police officers who guarded presidential candidates have not gotten their allowances to date. The Deputy IGP was in the Public Affairs Accounts Committee last week. And he said, yes, I've also learned that the people have not been, those officers not been given their allowances, but the Electoral Commission is the one in charge. So can we know from government, good enough Minister of Finance is here, did the Electoral Commission not get all of this money? Because they delivered on their duty, they should be paid. If anything, what we see nowadays is they are being hounded, they are being arrested, they have been dismissed from the police force, specifically those who are guarding the Honourable Kyagulanyi Ssentamu. For what? Doing their job. So you don't give them their allowances, which they are entitled to. Then you arrest them. Then you're dismissing them from the force. It is wrong. When people have worked, they need to be paid. And that money was passed here, Right Honourable Speaker. So I think it is important that we get to understand from government what happened. Did somebody take this money? Honourable Speaker, allow information from Senior Counsel. And then I'll also mention, because Honourable Speaker, you mentioned that regarding the alternative ministerial policy statements, Honourable Speaker, we are ready to begin laying even tomorrow. That's how effective we are as the opposition. So we request that you put us on the order paper. Tomorrow we shall be here.
That is how effective you have become.
That's how effective we have always been. I mean, last year we were here and we laid in good time, Right Honourable Speaker. And the Hansard can bear us witness. So even this time round, we are ready way ahead of time. So
you have them ready?
Right Honourable Speaker, kindly put us on the order paper tomorrow. We shall be here. We are very ready. Kindly take the information from Council.
Honorable Attorney General is talking about the arrests of people. Could you repeat what you said briefly on the arrest?
Thank you, Right Honorable Speaker. Right Honorable Speaker, I was emphasizing the imperativeness to follow the law in this our country. Attorney General was walking in. He's very well schooled in the law. I quoted Article 23, which provides for protection of personal liberty. I quoted Article 24 of our Constitution, which provides for, which actually inhibits and bars cruel treatment, inhuman treatment, and so on. But we continue to see the same happening, that people continue to be abducted. There's a young lady called Natabi Fauzia. She's wife to the personal assistant of the Honorable Chagulanyi Sentamu Robert. The home of this personal assistant was raided by men in UPDF uniform. One of them identified himself as SFC with his ID. They asked for where this gentleman was. He's called Nadia Sheriff Senyonjo. The wife said, I'm not too sure where he is right now. And they took the wife. That was Thursday last week. They left the little children unattended too. Up to now, we don't know where this young lady is. And that's what I've been emphasizing. It is wrong.
Okay.
I don't know what the Attorney General is going to explain to us, but these issues are problematic because it can happen to anybody regardless of where you belong. And I have said, if government is interested in anybody, please do issue us summons. And say, Joel Senyonyi, we require you tomorrow at this police station, at CIID headquarters at 9 a.m. I will be there at 8:30 because I'm a law-abiding citizen. But this business of picking people and then you cannot account for them for days, it is wrong. Okay. And it has to stop because otherwise it's going to eat up.
Okay. Honorable Attorney General, you've heard.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I've heard. I will confer with the Minister of Internal Affairs and find out what the issue is.
Thank you. Honorable Seungu.
Thank you, Madam Speaker. Madam Speaker, I want to thank you for your communication, but there's a matter I wanted to address again to this House through you about fire gutting markets. Yesterday, there was another challenge in Kampala. Katwe market was gutted, and we want to know exactly what's happening. Many people are constructing storage buildings in Kampala. Do they have water hydrants? How would you help this challenge? When we had the fire gutting schools, Ministry of Education had a lot of directives on schools having fire extinguishers, and indeed it solved some problems. But these people continue crying to government to help them, and we are not getting good information from government. Could we know what is happening in KCCA? A lot of markets are catching fire, and people are losing a lot of property and money. And what can be done in the instant case? Madam Speaker, as we talk now, owners of these markets are putting back their structures. But what can KCCA do to control fires? And the best solution is placing water hydrants in a number of areas. We need to get a status report.
So you've actually come out with a solution.
Yeah, we will, but
you've come out with a solution now that you are the house that does appropriation. So we should budget for that.
Madam Speaker, most obliged, but could we get some report about the challenges we are facing? Even Ginger had the same of recent. I think it was Ginger Market.
I want to refer you to the Sectoral Committee of Presidential Affairs. The challenges that are affecting KCCA are in that report. And if we can be able to address those challenges, then we'll be able to resolve most of these things. But all the same, government, you need to take note. Government, you need to take note of what Honorable Seungu is talking about.
Thank you, Right Honorable Speaker. Right Honorable Speaker, definitely I'll take this up with KCCA, with the Ministry for Kampala, and ask them to make a report to Parliament.
Appeal. Appeal.
Thank you very much, Madam Speaker. Thank you very much. Madam Speaker, I rise on a matter of national importance concerning a devastating windstorm destruction of classroom blocks, entire classroom blocks at Ototong Primary School over the weekend. That was on the 14th of March this year. That Honorable Speaker, this destruction has left almost 1,300 learners without safe and adequate learning spaces, as the roofs have all been blown off. And our prayer is that government, through the Office of the Prime Minister, provides temporary learning spaces, notably tents or tarpaulins, to ensure that the learners can continue attending school. But also we request for about 400 pieces of iron sheets to re-roof the classroom blocks. I thank you, Right Honourable Speaker.
Thank you. Have you got the disaster report from the district?
Yes, Madam Speaker, I'll submit it to the Office of the Prime Minister. Thank you very much.
Thank you. Government?
Thank you, Right Honourable Speaker. Right Honourable Speaker, I'll follow up with the Honourable Member, obtain this report and ensure that I get it delivered to the Office of the Prime Minister.
Thank you. Next item. Yes.
Right Honourable, I didn't want to come back on this issue, but now that the Attorney General is taking note to follow up with KCCA, the matter that's been raised by the Honourable Seungu about fires, I wanted to tether in this element. We saw a breaking of part of Owino Market, St. Baliku Dembe Market. KCCA went there, the leadership, and they said we have arrested those who were participating in breaking of a part of a building. A short while later, a few days later, KCCA now went back and they said these people, they demolished in a not very good way, so let's finish the demolition. That was KCCA itself. They said now that they didn't demolish properly, so let's now raise down the entire building. And so people have been reaching out to us and saying, do help us. KCCA came and said they have arrested those who were demolishing. Now they came back and they said, let's finish the job. The other ones didn't do it very well. I think that the Minister for Kampala needs to tie that into the report that she's going to bring, so that we get clarity. There is a lot of confusion.
Thank you.
Right Honourable, with your permission, allow 30-second information from the Shadow Minister for Kampala and the Kampala Lord Mayor-elect, with your permission.
Thank you, Right Honourable Speaker. I personally visited the site before the demolition at night. And the affected people told me that actually the market master of Owino Market, who represents KCCA, had warned the people and told them to vacate, for they were going to be evicted. And when I called the ED's phone was off, but I later called the deputy ED, who told me they had no arrangement of evicting the vendors because they are chasing off the street the illegal street vendors into the gazetted markets, and therefore they had no reason whatsoever to again evict people from the markets. Unfortunately, that very night, it's when the demolition went on. And sad to say, we lost a life there. Someone died. And I hear now there are 2 that died. So we need a thorough report from the minister. And maybe, Right Honourable Speaker, it would be even much better for you to constitute a committee to investigate into that matter, because it's a serious matter. I called the ED, who later told me that she had actually given a demolition order or permit to the developer. And at first, the developer hasn't known Everyone was running away from that act. So don't you think, Right Honorable Speaker, you need to constitute a committee of Parliament to investigate into that matter, because it's a serious matter. Very serious.
Honorable members, I am aware that KCCA is appearing before the Committee of Park tomorrow, and most of those issues, COSASE, most of those issues must be handled by the chair and the committee, and I see a number of committee members of KCCA here. So interrogate KCCA on those matters, and then COSASE, interrogate KCCA on those matters, and then you will report back. We already have a committee of COSASE handling KCCA. So it will not be good for us to form another committee. Yes, Dennis?
Thank you very much, Right Honorable Speaker. I am raising on a matter of national importance, touching our health sector. Right Honorable Speaker, between 2022 to 2025, the graduate nurses and midwives at extension level, to be specific, those that are extending from certificate to diploma and then from diploma to bachelor's, government did not provide funds for their placement. And by virtue of the fact that there were no funds allocated for placement, government waived placement for the said students. But to date, they have not been issued with their practicing licenses. And by law, they cannot practice anywhere in this country. I pray that government expedites the process of coordinating its other organs and release licenses for these Ugandans. Thank you very much.
Dennis, when the budget process and the sectoral committees are sitting, go to the sectoral committee of health, bring up that issue, and that issue will be resolved. The next item.
Item 3 on the order paper, laying of papers. 3A, forensic audit report into the alleged misappropriation of funds for the construction of Kololo Seed Secondary School, Maracha District.
Honorable members, Article 163(3)(a) of the Constitution of the Republic of Uganda and the National Audit Act, Section 13(1)(a) of the National Audit Act 2008 mandates the Auditor General to audit and report to public accounts of Uganda, and pursuant to Rule 188(4) of the Rules of Procedure, I will invite the Parliamentary Commissioner to lay on table.
Right Honorable Speaker and honorable members, I beg to lay the report of name the forensic audit report into the alleged misappropriation of funds for the construction of Kololo Seed Secondary School, Maracha District. I beg to lay the report on table.
Thank you. The report is referred to the committee, to the relevant committee.
Item 3B, report of the Uganda delegation to the 54th Commonwealth Parliamentary Association Africa Regional Conference held in Banjul, the Gambia, 10th to 16th August 2025.
Honorable members, Rule 34 of the Rules of Procedure of Parliament requires parliamentary delegations abroad to report back within the 14 days of coming back, and much as we pass the 14 days, but Honorable Elijah Cooper is ready to give us a brief.
Thank you, Right Honorable Speaker. Like you have stated, in compliance with Rule 34(1) of the Rules of Procedure of Parliament of Uganda, allow me to lay a report of the Uganda delegation to the 54th CPA Africa Regional Conference held in the Banjul, the Gambia, between 10th to 16th of August 2025. The theme of the conference was strengthening democratic governance and resilience in Africa, tackling conflicts, economic shocks, and climate risks. Right Honorable Speaker, honorable colleagues, the list of the members that attended is attached. The resolutions and the recommendations are here in this report. Right Honorable Speaker, allow me to lay report on the table. Right Honorable Speaker.
Thank you, Honorable Elijah. And pursuant to Rule 34(3) of the Rules of Procedure, we will deposit that report to the library. You can get it and read it anytime when you're able to do it, and then we'll set a date for a debate later.
Item 3C, report of the Ugandan delegation to the 68th Commonwealth Parliamentary Association Conference, Bridgetown, Barbados, 5th to 12th October 2025.
Honorable Elijah.
Thank you, Right Honorable Speaker. Again, as per Rule 34(1) of the Rules of Procedure of the Parliament of Uganda, allow me again to lay on the table the report of the Ugandan delegation to the 68th Commonwealth Parliamentary Conference, which is an annual conference in Bridgetown, Barbados, the Caribbean, which took place between 5th and 12th of October 2025. The members who represented Uganda Parliament, the list is attached. The theme of the conference was the Commonwealth, a global partner. Right Honorable Speaker, again, the resolutions and the recommendations are here in this report. Allow me again to lay it on the table.
Thank you.
Right Honorable Speaker. Right Honorable Speaker, as I get to sit, I want to thank you because one of the members of the CPA Uganda branch, who happens also to be the treasurer of the CPA Africa region, our colleague, I want to thank you for visiting him in the hospital yesterday. And colleagues, when you get time, please check on our colleague at IHK Hospital. Honorable Enos Tusime, some unfortunate incident that happened to him. For members who have just come in, the speaker had reported in her communication he was attacked. But we thank God he's alive and is recovering. If you get time, please check on him at IHK Hospital.
Thank you.
Right Honorable Speaker.
Thank you so much, Honorable Elijah. Pursuant to Rule 34(3) of the Rules of Procedure, we will still deposit this to the Parliamentary Library, and will assign a date for debate and have it completed.
Item 3D, value for money audit reports on 3D1, the implementation of solar-powered water supply and irrigation systems by the Ministry of Water and Environment.
Parliamentary Commissioner.
Right Honorable Speaker and honorable members, I beg to lay the report of the Auditor General on the implementation of solar-powered water supply and irrigation systems by Ministry of Water and Environment. I beg to lay the report on table.
Thank you. Pursuant to Rule 18, Sub-Rule 3 and 4, the report is referred to the Committee of PAC, Central Government.
Item 3D2, value for money audit report on the management of remand homes and the rehabilitation center by the Ministry of Gender, Labor and Social Development.
Commissioner.
Right Honorable Speaker and honorable members, I beg to lay the report of the Auditor General on the management of remand homes and the rehabilitation center by Ministry of Gender, Labor and Social Development. I beg to lay the report on table.
Thank you. Pursuant to Rule 18, Sub-Rule 3 and 4, The report is referred to the Committee of Public Accounts Committee, COSASE.
Item 3D3, the monitoring and enforcement of noise pollution standards by the National Environment Management Authority and selected cities.
Right Honourable Speaker and honourable members, I beg to lay the report for value for money audit on monitoring and enforcement of noise pollution standards by the National Environment Management Authority, NEMA, and selected cities. I beg to lay the report.
Thank you. Pursuant to Rule 1A, Sub-Rule 3 and 4, the report is referred to the Committee of PAC, COSASE.
Item 3D4, value for money audit report on the implementation of land administration by the Ministry of Lands, Housing and Urban Development through the Ministry zonal offices.
Commissioner.
Right Honourable Speaker and honourable members, I beg to lay the Auditor General's report on the implementation of land administration by Ministry of Lands, Housing and Urban Development through Ministry zonal offices. The report is here. I beg to lay.
Thank you. Pursuant to Rule 1A, Sub-Rule 3 and 4, the report is referred to Committee of PAC, Central Government.
Item 3D5, value for money audit report on the evaluation of the business registration and licensing and tourism competitiveness development interventions under the Competitiveness and Enterprise Development Project.
Commissioner.
Right Honourable Speaker and honourable members, I beg to lay the report on the evaluation of the business registration and licensing and tourism competitiveness development interventions under the Competitiveness and Enterprise Development Project. I beg to lay the report on table.
Thank you. Refer to the Committee of PAC, Central Government.
Item 4 on the order paper, Bill second reading, the Copyright and Neighboring Rights Amendment Bill 2025.
Honourable members, you recall that last week on Thursday, 12th March 2026, the House stood over the debate on the motion for the second reading of the bill, pending clarifications of the contentious issues arising out of Clause 9 of the bill, which is a gist of this bill. We, as I said before, we had a clarification on that clause. However, I will allow the debate to continue. Then that clarification will be made when we reach committee stage. But I want to reiterate this. Nobody should imagine that we didn't want to make the bill. And it is also not prudent for people to sit wherever they sit and start saying we members of parliament are ignorant. We are not ignorant. We are here to work for the public. The debate is open. Yes, Christine. Yes, procedure.
Right Honourable Speaker, thank you so much. You just mentioned in your communication that yes, indeed the House debated that report and was supposed to proceed on the committee stage. Are we therefore proceeding well when we say that we go back to the debate instead of going straight to the committee stage?
I said we are continuing with the debate. Christine.
Right Honourable Speaker, thank you so much. Actually, it is very important that we continue with the debate for people out there in the public to see and listen to what different thoughts are. Because
Christine, is that in the report?
Right Honorable Speaker, I'm discussing Article 9 of the report of the committee
I have
report.
said Article Clause 9 will be discussed when we are at committee stage.
Yes, Right Honorable Speaker, I was building my submission, Right Honorable Speaker. I am saying that based on the report, we needed to profile the different stakeholders. For example, when you look at the upcoming and the already established, the report is not bringing out the difference of the interests of these two groups and the expiry of the consideration of the different interests. Because this did not come out, Right Honorable Speaker, in the report. When the interests have an expiry date, that is a consideration for you for this period of time. Right Honorable Speaker, the freedom, I still emphasize that the freedom of when something is exposed to the public, the freedom of the public to enjoy something produced for the public is also missing. To what extent should the public enjoy what you have put forward, especially when you have put it forward? If, as a right, if you didn't want the public to enjoy at all, then to what extent should the public be given that freedom to enjoy what you have put on table? That is still a question from the report, Right Honorable Speaker. Thank you.
Thank you. Yes. In the yes, Attorney General.
Thank you, Right Honorable Speaker. And I thank the Honorable Member for the question. I'll just make this analogy. I manufacture a car for purposes of selling it. But because I manufactured it for purposes of selling it for the public to use, we cannot argue that I should be able to access that car without paying for it. Now, this copyright is that property. It is what the artist has made. And he has made it for the purpose of the public using it, but he has made it for the purpose of gaining from it. So this law has provided the instances how you could use it. If you want to enter into an agreement with the artist, you could enter the agreement, and the artist could give you time. And there are limits. 20 years, 15 years, all those are provided for in the Act. So the right of the public to use the works of the artist are regulated by the law. It is not that when they produce the music, you are at liberty to use it for your benefit, for your commercial benefit, without them benefiting from it. So yes, it's provided for. If you want to use it, you can agree with them. If you want to sell it, you can also agree with them on how you can sell it. So we need to look at it as the property, that this copyright is the property of the artist, and you would like to use that property. How do you want to use the property?
This is a house. They don't clap. Place.
So yes, the way the law is structured, the way the copyright law is structured, it is alive to the fact that the artist would like to sell that product. But how do they sell that product to the public? That's what the law is trying to regulate.
And Christine, you also have an option. If you do not want to enjoy the product, then you decide not to. But if you want to enjoy, you must be able to pay the owner of the product. You get it, eh? Zach, Kabandeke. Tebandeke.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I happen to be a gospel artist. And I've interacted severely with very many upcoming gospel artists, including the pastors that are ministers over the same. Right Honorable Speaker, I'm not so certain whether all stakeholders were consulted enough to accommodate their input into this bill. And yet it is for public consumption. Right Honorable Speaker, in accordance to Luke chapter 6, verse 38, if permission granted to read it verbally.
Honorable Tebandeke, Honorable Tebandeke, Honorable Tebandeke, you're only speculating. There was an advert which was even paid by Parliament of Uganda, inviting everybody to come and bring their views. And when you look at the report, it's unfortunate that when they read the report, you're not here. It gave all the people who came here. So if somebody missed out, we cannot go and pick somebody from their homes to come and give their views. So we will take the views that were given and consider the bill. We are not going to keep this bill forever. Okay? Honorable members, I put a question that the Copyright and Neighboring Rights Amendment Bill 2025 be read the second time. Those in favor say the contrary nay. The ayes have it.
The Copyright and Neighboring Rights Amendment Bill 2025, Bills Committee stage. Clause 1.
Clause 1, Chair.
Thank you, Madam Chair. Madam Chair, the committee proposes amendments to Clause 1 in the following terms. Clause 1 is amended in paragraph 1A as follows. In the definition of broadcasting, by inserting immediately before the word wireless, the word wire.
Chair, can we stand over Clause 1 in case we shall get something else to define?
In the definition. Thank you.
Clause 2.
Clause 2. Clause 2, I put a question that Clause 2 stands part of the bill. Those in favor say on the contrary there. The ayes have it.
Clause 3.
I put a question that Clause 3 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
New clause.
New clause.
Madam Chair, we have a new insertion of a new clause immediately after Clause 3. In the following terms. The bill is amended by inserting immediately after Clause 3 the following. Insertion of Section 4A in the Principal Act. The Principal Act is amended by inserting immediately after Clause 4 the following. 4A, artificial intelligence work to be protected. Works generated by an artificial intelligence system.
Immediately after Clause 3.
Yeah. Immediately after Clause 3, which will be 4A. And 4A is the head note is artificial intelligence work to be protected. Works and 4A1, works to be generated by an artificial intelligence system shall be eligible for copyright protection if the works A has been supervised, directed or substantially modified by a natural person, and B is original. 4A2, a developer or user who intends to develop any work using an artificial intelligence system shall 2A, obtain the consent of the author of the work to be used in training data set, and B, maintain publicly accessible records of the general categories and sources of content used in training data set. 4A3, a developer shall implement technical safeguards to prevent the reproduction of training data and shall provide clear usage guidelines to users to the use of artificial intelligence tools. 4A4, the minister may by statutory instrument A, regulate the use of copyright works in artificial intelligence systems, and B, prescribe the criteria to be applied to works generated using artificial intelligence systems to determine whether the work is original. Justification, Madam Chair, to provide for works which are eligible for copyright protection and the use of copyright material in artificial intelligence systems. 2, to empower the minister to prescribe the criteria to be applied to works generated using artificial intelligence systems to determine whether the work is original. I beg to move, Madam Chair.
AG.
Right Honorable Speaker and Honorable colleagues, we propose that that provision, that insertion be dropped by the House. Right Honorable Speaker, AI is a tool. It's a tool used to generate protected work. AI is not in, this act is not intended to regulate tools. For example, a musician uses an organ, a drum, a long drum. This act is not about the tools that you use to generate the works. This act is about the works themselves. So the AI policy is much wider, and government is currently working on AI policy on how to regulate and guide people on its use. But to say that we should attach certain value to how the copyright was made would not be appropriate. We propose that that proposed amendment be dropped.
Honorable Baka, I think what AG is saying is correct.
Madam Chair, considering that you want to allow debate on this, Madam? Considering that, Madam Chair, we have made a recommendation.
Do you have any law on AI?
We have made a recommendation in our report. That
No, I'm saying, do you have a law that you're referring on AI for you to borrow?
We received the
and in the circumstance that you don't have, then just concede.
Yeah, can I just make a statement and conclude, Madam Chair, and then you rule? Madam Chair, first of all, I concur with the Attorney General for now that provisions relating to AI need to be looked into further. And we made a recommendation to that effect, that government should take interest in AI matters and amend the Copyright Act further. But for now, I concede.
Next.
Clause 4.
I put a question that clause 4 stands part of the bill. Those in favor say the contrary, nay. The ayes have it.
Clause 5.
Chair.
Madam Chair, clause 5, the committee proposes amendment to clause 5, which is section 13 of this Principal Act in the following terms. Clause 5 is amended in the paragraph B by substituting for subsection 4 the following. A contract of assignment, license, or transfer to do an act falling within a copyright shall be in writing. Justification: for completeness, to harmonize the provision with the head note by including the assignment and transfer of a contract in the proposed subsection 4. I beg to move.
Thank you, AG.
Right Honorable Speaker, we have no objection to that proposed amendment. The import of it is that if you want to deal with an assignment or a license of the use of any person's copyright, you can only do so by showing that you have a contract in writing. We do concede.
Thank you. I put a question that clause 5 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 5 as amended.
I put a question that clause 5 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 6.
Madam Chair, clause 6, the committee proposes to insert section 13A and 13B in the Principal Act, and therefore clause 6 will be amended as follows. By substituting the proposed section 13A, the following. 13A, reversion of economic rights in copyright to author. 13A1, in a contract of assignment, license or transfer, there is an implied term that the economic rights in a copyright shall revert to the author. A, upon termination of the contract of assignment or license or transfer. B, upon expiry of the term of the contract of assignment, license or transfer. C, if the holder of the economic rights in the contract of assignment, license or transfer becomes insolvent or bankrupt and can no longer meet the contractual obligations to the author. D, where the contract of assignment, license or transfer covers the right of publication, the work goes out of print or becomes unavailable or for a reasonable time. E, 5 years before the expiry of the duration of the protection of the copyright works under this act, or F, for any other reason as may be prescribed by the minister by statutory instrument. 13A2, the minister may by statutory instrument prescribe the procedure of reverting the assignment, license or transfer of copyright to the author. 13AB, in section 13B1, the proposed paragraphs A and B, by deleting the word effective wherever the word appears in the provision. And in the proposed paragraph B, by inserting immediately after the word technological, wherever the word appears, the word protection. Justification, Madam Chair. The proposed 13A is replaced since the provision as proposed in the bill will frustrate freedom of contract and unlawfully deprives copyright owners the full utilization of their rights. The second justification, to adopt international best practices that allow the reversion of the rights of an author under specific circumstances. The other justification, to empower authors who have assigned their rights in a copyright works for the life of the copyright prior to the commencement of the Copyright and Neighboring Rights Act to claim back their rights 5 years before the statutory protection of the rights. And the amendment proposed in 13B are intended to delete the word effective since the word is redundant and subjective, and to insert the word protection in order to harmonize the provision with the usage of the word under the World Intellectual Property Framework. I beg to move, Madam Chair.
AG.
Right Honorable Speaker and Honorable colleagues, the proposed replacement of clause 13A by the committee will not work in the best interest of the author. The purpose of the proposal that has been made by government is that you cannot have a copyright on any person's works for a period longer than 20 years. And that and 5 years before that, the owner of the copyright is at liberty to come and take this property back. What this clause is doing, it is mixing up the consequence of termination with the right for reversion. So what we are discussing here is the right of the author to get their works back after the 20 year, and you cannot have a copyright for say 40 years. It can only be a maximum of 20 years. You can write another contract. But the purpose of this was to ensure that if an author, for example, in year 1, entered into a contract for a long period, which was, say, unfair because of the bargaining power, after some time they can get benefit back of their product. We propose, Right Honorable Speaker and Honorable colleagues, that this proposal be dropped and clause 6 stands as part of the bill as proposed by government. We so submit.
Seungo.
I want the Attorney General to guide me on this, and the chair of the committee. Madam Chair, you see, in the copyright law, I compose my song. And after composing my song, a certain man wants to buy my album. Remember some time back, there was no TikTok, there was no whatever they use on social media. And this man, Kasiwukira, may he so rest in peace, bought my music. But by that time, I even never had the capacity to record a video out of my music. But has the right over the song. I don't know whether Attorney General you are following what I'm saying. Now, because it is my song, I composed it. Now, he paid me. He has been selling my music. I got my money. But now I'm composing. I'm putting in a video. I'm recording a video which I'm also going to sell. I want to say how this musician is protected under that direction. Because he's putting his music on TikTok, he's putting it on YouTube, which were not present at that particular time. But now the advantages he's using to sell and get money, which were not available by the other person who had bought the copyright by that time. Can you help me get that one, in that particular clause?
Honorable Seungu, first of all, I want you to know the heading of the clause, reversal of copyright to an author. So let's discuss according to that. You get it? Eh? We are looking at when do you reverse, how do you reverse. Let's be systematic. Move as per the clause. Okay? I don't want the work to be distorted on the Hansard.
Madam Chair,
are you conceding to what the AG had said?
Yeah. What we seek to achieve is that the reversionary interests of the author are protected. And if you look at the Attorney General's contention, it does not water away that intended purpose, that the reversionary interests of the author are protected. So I concede on that.
I put a question that clause 6 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 7.
Chair.
It's becoming juicier now. Clause 7, Madam Chair, is amended in the following terms. Clause 7 is amended in paragraph B, in the proposed paragraph 1, by inserting immediately after the word museum, the words for use by a beneficiary person other than for commercial use. Justification: the amendment will protect rights owners' interests by limiting access to their works by beneficiary persons as required in the Marrakesh Treaty to facilitate access to published works by persons who are blind, visually impaired, or otherwise print disabled.
Right Honourable Speaker and Honourable colleagues, the import of the provision in clause 7, amending section 14 of the Principal Act, is discussing the fair use of works protected by copyright. The purpose of this provision is to allow the use of copyrights for educational, institutional, library, and that kind of thing, not for commercial purposes. Now, when you say for use by beneficiary person other than for commercial use, you're limiting that to only the beneficiary person. Now, that beneficiary person could only be a person who is a beneficiary through a license, through a contract, and through that kind of introduction. So, we note that we need to protect the rights of owners, and we also need to observe fair use of these products, and that is why clause 14.2 is introduced. So we propose that the provision in clause 7 in relation to amendment to section 14 L, be left to read, the work is used in an online learning environment by an education institution, library, archive, or museum, full stop, but not for the beneficiary person or other than for commercial use.
Chair.
Madam Chair, the Attorney General should then explain how you protect access of published works by persons who are blind, visually impaired, or otherwise print disabled. How do you protect them?
Thank you. Chair. Of course, government currently, when we are dealing with our education institution, we take into consideration all the needs of all the persons, even those ones who are visually impaired, those who are impaired in any other way are provided for. So when you say for educational purposes, it is encompassing all the person in the educational
Attorney
space.
General, K protects what he's asking about.
Fair enough. I'm
You
satisfied with
read K.
K.
K on the bill.
In the bill.
Yes.
Does it?
It does protect.
I concede.
Okay. Attorney General. Attorney General. For avoidance of doubt, just restructure your statement, the amendment.
Right Honorable Speaker, we propose that clause 7 of the bill stands as it is in the bill currently, and that the proposal made by the committee should not be adopted, because clause 14 properly caters for all educational purposes for which the copyright could be used. Beg to submit.
Thank you. I put a question that clause 7 stands part of the bill. Those in favor say on the contrary. The ayes have it.
Clause 8.
Chair.
Madam Chair, the committee proposes amendments to clause 8, which is amendment of sections 14 and 14 in the Principal Act in the following terms. Clause 8 is amended in the proposed section 114B2 by inserting immediately after the word found the words identified or is unknown. Justification to harmonize the provision with the definition of the phrase orphan works in clause 1 of the bill.
Right Honorable Speaker, Right Honorable Chair, and Honorable colleagues, yes, we do concede that the proposal as made by the committee widens the scope of orphan works and clarifies it as defined in clause 1. We concede to the amendment by the committee.
I put a question that clause 8 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 8 as amended.
I put a question that clause 8 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 9.
Clause 9. Honorable members, I'm in receipt of a letter from one of the members pursuant to Rule 140, Sub-Rule 4 of the Rules of Procedure, and the member is Honorable Kabanda on the amendment of Clause 9. And I'll invite Honorable Kabanda to move his amendment.
Right Honorable Speaker, thank you so much for allowing me to make some amendments on clause 9. As you have said, I wrote to you on the 9th of March 2026 notifying you about my intentions to move an amendment to clause 9 of the bill pursuant to Rule 140 Sub-Rule 4 of the Rules of Procedure. Right
Yes,
Honorable
go ahead.
Speaker, I was unable to submit to the committee because by the time the bill was under consideration, I was away on official duty. Right Honorable Speaker and honorable members, I beg to move the following amendments to clause 9 of this bill. Right Honorable Speaker, I move that clause 9 be substituted for the following. Section 30 of the Principal Act is amended by A. I am by substituting for the proposed subsection 1, where a sound recording or audiovisual fixation published for commercial advertisement purposes or a reproduction of that sound recording or audiovisual fixation is used directly or indirectly by broadcasting or other communication to the public, or is publicly performed unless otherwise agreed. An equitable remuneration determined by the minister in consultation with the registrar and relevant stakeholders for the performer or performers and the producer of the sound recording or audiovisual fixation shall be paid by the user to the author for every use of the work. B. By inserting immediately after subsection 1 the following. The remuneration referred to in subsection 1 shall be paid through a payment system established under the National Payment Systems Act. B. 1B. The registrar shall, for purposes of this section, monitor the use of a sound recording or audiovisual fixation for commercial advertisement purposes or for broadcasting or other communication to the public, and send periodic reports to the minister. Right Honorable Speaker, 1C, the minister may, in consultation with the registrar and any relevant stakeholders, by statutory instrument, prescribe the procedures for collecting, distributing and receiving royalties and other entitlements from use of copyright or neighboring rights. Just to justify, to streamline the procedure for collection, payment and distribution of royalties to the author. I beg to amend.
Thank you, Chair.
The committee did not propose any amendment to this clause because this clause, the purpose of the clause was to require any person who uses or entity who uses copyrighted materials for commercial purposes to pay a levy. This will enhance revenues for our creatives. It will expand the industry and it will help energize and enhance the work of our creatives. So that purpose has not been lost in this amendment. I have noticed that the amendment still maintains that purpose. What I've noticed in the amendment is just streamlining who is going to determine the equitable payments, because equitable is subjective. So to avoid ambiguities around the issue of equitable payments, this amendment seems to clear that. It says the minister, in consultation with the Registrar General and stakeholders, the stakeholders being the creatives through their CMOs. And then the other one, I think, was on how payments will be done through a system that is well known to us through the bank, such that money is not, you don't just go to a radio station or an entity and you are given money in a bag. The money should go through a system that is established. So I concur with the amendment. It does not change the substance of the clause, and so as a committee, I think we are okay with it.
Thank you. AJ.
Thank you, Right Honourable Speaker. Right Honourable Speaker, upon receipt of your notification of this amendment, we did have a chance to consider this and even had a chance to discuss with the stakeholders who are available on this. We have no objection to this amendment.
Thank you. I put a question that clause 9 be amended as proposed by Honorable Kabanda, agreed with the chair of the committee and confirmed by the Attorney General. Those in favor say to the contrary, nay. The ayes have it.
Clause 9 as amended.
I put a question that clause 9 as amended stands part of the committee. Those in favor say on the contrary, nay. The ayes have it.
Clause 10.
Clause 10. I put a question that clause 10 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 11.
Madam Chair, clause 11, the committee proposes amendments.
Before you go to clause 11, I can first introduce our guests who are up there. We have Edirisa Kenso Musuza. You're welcome. Karunji Shiva. Pius Palazzo. Joseph Mayanja. Chameleon. Moses Saleh. Martin Moomuza. Michael Kalumba. Lillian Mbabazi. Lord Fred Sevata. Alex Lokuten. Cindy Sanyo. Daniel Kazibwe. Ragadi. Pastor Wilson Bugembe. Pastor, where is Pastor? Martin Musoke. Joanita Kawalia. Matthew Nabwiso. Nathan Magola. Cassandra Richard. Kansime Ann. Annette Nanduja. Aisha Nava Ziwa. Sewanyana Malcolm. Raymond Kaisa. Richard Mugisha. Shine Nyashosh. Okuni Edward. Sulaiman Luanga. Halima Namakula. Muzee Idi Masawa. Ronald Mainja. Charles Musoke. Cheyune Mohammed Habib. Nkaluvo Rona. Lubega Edris. Chachimwa Jen. Agaba Ezra. Exodus. West King. Emrys. Bruno. Kamugisha Abia. Sandy Jafaruk. Muinda Rao. Fanta Busoga. Kabi Fred. And Kironde Vidi. You're all welcome. Join me in welcoming them. We also have our own Hildaman. We also have our own Obangaina. We also have our own. We have Balam. And then we have Orone. Chairman Orone. And then we have Chairman, Kayemba Solo. You're all most welcome and thank you for coming. Silo. We also have Silo. Honourable members, can we finish the bill? In the VIP gallery, we have Honourable Margaret Tilu, a Member of Parliament elect Amuria. We have Honourable Emmanuel Baira, Blambuli County. We have Honourable Kainza Agnes from Budoda. You have Honourable Wanyoto Godfrey from Budadiri West County. You're all most welcome and thank you for coming. Clause 11.
Clause 11.
Madam Chairperson, Clause 11 is an insertion of Section 39A in the Principal Act. Clause 11 is amended in the proposed Section 39A, 39AA in subsection 2 by substituting for paragraph A the following. A, author 30%. 2, by inserting immediately after the paragraph A the following, performer 30%. B, by inserting immediately after subsection 2 the following new subsections. The remuneration to be paid under subsection 2 shall be computed on the net revenue earned by the person exploiting the works of the author or the performer as collar ringback tone after payment of any applicable taxes. A contract for exploiting the works of the author or performer as collar ringback tone in existence before the commencement of this act shall continue in existence as if the same was made under this act, except that the remuneration under the contract shall be the rate prescribed under subsection 2. Justification, Madam Chair, to assign the author and performer separate entitlements, since each has individual rights in the copyright over collar ringback tones. Second justification, to extend the validity of contracts for collar ringback tones and require the payment of rates prescribed under the bill. Finally, justification to specify for clarity that the remuneration is based on the net revenue after tax. I beg to move.
Thank you. AG.
Thank you, Right Honourable Speaker and Honourable colleagues. We have no objection principally to the amendment as it aligns with government's policy to protect the creatives in the industry. Just Right Honourable Speaker, in line with the proposed amendment, Clause 9, we propose that the remuneration to be paid under this clause, under Clause 11, be paid through the payment system provided for under the NPA Act, National Payment Systems Act.
Amendment.
So I'm proposing that consequent to the amendment in Clause 9, we amend Clause 11 to include that the payments made under this clause shall be made through the National Payment System as prescribed under the National Payment Systems Act. I beg to
Thank you. I put a question that Clause 9 be amended as proposed. Those in favor say on the contrary, nay. Those in favor say on the contrary, nay. The ayes have it.
Clause 11 as amended.
I put a question that clause 11 as amended stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 12.
I put a question that clause 12 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 13.
I put a question that clause 13 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 14.
I put a question that clause 14 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 15.
I put a question that clause 15 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 16.
I put a question that clause 16 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 17.
Chair.
Madam Chair, clause 17 is insertion of section 49A in the Principal Act. Clause 17 is amended in the proposed section 49A by substituting for the subsection 4 the following. The registrar shall not issue an order or a notice for blocking, taking down, or obstructing of infringement content unless the owner of the copyright proves that an infringement of copyright works has occurred as required in section 45. Justification to harmonize the proposed section subsection 4 with section 45 of the Principal Act, which describes an infringement of copyright and neighboring rights, is deemed to take place. Second justification, the certificate of ownership is not proof of infringement since it does not contain the copyright alleged to have been infringed. The proposed subsection 4 is amended since it has the effect of introducing mandatory registration of copyright works in contravention of the provisions of section 3(1) and 2 of the Principal Act and principles prescribed under the World Intellectual Property Organization framework, which grants blanket protection to any copyright works without any formalities such as registration. I beg to move, Madam Chair.
AG.
All right, Honorable Speaker and Honorable colleagues. We do appreciate the spirit that the committee raises here. However, a clear reading of the entire clause 49 shows that there is a process that you must undertake before a taking down of the works is concerned. However, I am concerned with the reading which says the registrar shall not issue an order or notice blocking, taking down, obstructing of an infringing content unless the owner of the copyright proves that an infringement of the copyright works has occurred as required by section 45. Right, Honorable Speaker and Honorable colleagues, the exercise of copyright activity is not necessarily one that should go to court, because if the owner of the works comes and says that person is using my work without my permission, the registrar should be at liberty to take that down. But if we start talking about proof, then we are saying we have to first go to court, how long it's going to take in court, and etc. After all, the person who has put up the works, if they have a valid claim over those rights, they can still have them enforced. So I propose that the amendment proposed here, it places an onerous task on the owner of the copyright to prove infringement, whereas all they need to say is that I did not authorize you to use my works. And the provision as we have it here, Right Honorable Speaker and colleagues, I think covers that. I propose that that proposed amendment be dropped and clause 17 of the bill does stand as proposed.
Chair.
Madam Chair, the original clause 17 requires the registrar to do obstruction, take down orders when a copyright owner has presented a certificate of registration. And we are saying that is wrong because a certificate of registration, we have already rejected it earlier. Because this is the creatives, once you have a work that you have produced, your rights accrue upon publication of that work, not registration. So if you leave here registration as a condition for the registrar to take down the works that have been infringed upon, then you are saying the creatives must go and register their works, which you are saying no, they don't have to register their work, because that right accrues. As soon as you produce a work, the right accrues, you don't have to register. So the only way out is for the rights owner to go and prove that they are the ones who produced that work, not a certificate of registration.
Right, Honorable Speaker.
Can I find out, does one have to register a copyright? No, I am asking, I'm not asking you. I'm asking you.
You can register
Not
a
you
copyright.
can. You must register.
No. The right. Your
The right,
because
that is okay.
There are rights that accrue upon registration.
Yes.
But whether I've registered or not, I am the copyright holder.
Yes.
Yes.
But
And whether I've registered, Madam Chair,
as a creative.
Madam Chair, and whether I've registered or not, I am protected under the law. Yes. I am protected under the law.
Order.
Right, Honorable Chair. The Honorable Member is correct that once a creative produces his work, he has a right to that work. But for you to benefit from the protections provided by the law, you must register. Because you will find it very difficult to tell someone that they're infringing your rights when they did not know they were your works. So you need to register your rights in order for you to protect yourself under the law.
Because anyone can claim. You must register.
Your right exists by virtue of your
Honorable Baka, there is a right by virtue of creation. But for you to protect that right, you must register that creation.
Madam
Yes.
Chair, Madam Chair, I have seen flowers from up. I've seen the purpose, the committee was intending to protect the creatives, but I've seen the flowers for the Attorney General, so I concede.
I put a question that the I put a question that clause 17 stands part of the bill. Those in favor say the contrary, nay. The ayes have it.
Clause 18.
I put a question that clause 18 stands part of the bill. Those in favor say the contrary, nay. The ayes have it.
Clause 19.
19, Chair.
Clause 19, there is a proposal by the committee. Clause 19 is amended by deleting paragraph B. Clause 19 is amended by deleting paragraph B. Justification, Madam Chair. The proposed subsection 3 is redundant in light of section 45 of the Principal Act, which describes when an infringement of copyright and neighboring rights is deemed to take place. The proposed subsection 3 is deleted since it has the effect of introducing mandatory registration of copyright works in contravention of the provisions of section 3(1) and 2 of the Principal Act and Article 5(2) of the Berne Convention and Article 20 of the World Intellectual Property Organization Performances and Phonographs Treaty, which the bill seeks to domesticate, which prohibit the imposition of formalities on both the enjoyment and enforcement of copyright works.
Eje?
Thank you, Right Honorable Chair. Right Honorable Chair, we propose that subclause 3 remains part of the bill. Subclause 3 as proposed by government is that the adequate evidence referred to in subsection 2 may include a certificate of registration. Right Honorable Speaker, Right Honorable Chair, the import of this provision is that the moment a creative produces a certificate of registration, that is adequate evidence that they are the owner of that copyright from the registrar, the copyright registration. So to remove it, this proposal was being made in line with the proposal to amend clause 16. But since clause 16 did not pass, we propose that clause 3 of the principal bill do stand.
Madam Chair, after what we have agreed upon in the previous clause, which was clause 19, clause 17, clause 19 consequentially has to remain as it was. So I concur with the Attorney General.
I put a question that clause 19 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 19 as amended.
There's no amendment.
Clause 20.
Madam Chair, clause 20 substitution of subsection 56 of the Principal Act. Clause 20 is amended in the proposed section 54 in the following terms. In subsection 1, by substituting for the words a group of persons, the words any 30 or more people. B, in subsection 2, by inserting immediately after paragraph A the following new paragraphs: a copy of articles and rules of the collecting society, a copy of the certificate of incorporation as a company limited by guarantee without share capital issued by the Register of Companies, and C, by substituting for subsection 3 the following: the registrar shall not register any two collecting societies in respect of the same band of rights and category of works. Justification: to group the persons as used in the bill is ambiguous and will force enforcement challenges, since it is not certain as to how many people are required to establish a collecting society. The other justification, Madam Chair, to harmonize the provision with Section 58 of the Act, which require a collecting society to have 30 people as a minimum. To require collecting societies be incorporated by the Register of Companies and regulated by the Register of Copyright in order to separation incorporation of collecting societies, in order to separate incorporation of collecting societies and the regulation of their operations. To require collecting societies to be not for profit organizations, and to restrict the registrar to only register not more than 2 collecting societies for each bundle of rights. I beg to move, Madam Chair.
AG.
Thank you, Right Honorable Chair. Right Honorable Chair and honorable colleagues, the committee proposes to amend clause 20 by inserting immediately after a group of persons any 30 or more people as who intend to operate a collecting society. Right Honorable Speaker and honorable colleagues, this bundle of rights are different. You have musicians, you have artists, you have now new groups called TikTokers, you have YouTubers, you have bloggers, you have all manner of people. And to say that there must be 30 crafts, to say that there must be 30 to create a collecting society for a bundle of rights is wrong. Because that means that if there are only 3 who do that activity, then they can't be paid. So we are saying any group of persons who intend to operate will apply and register, so long as the registrar shall not register more than one group for each bundle of rights. And whether they are 5, 10, 100, that's one bundle of rights. And therefore, that proposal will create a challenge for the artists, especially if we want to write a law which is going to surpass time. Things could change. Secondly, Right Honorable Speaker, Right Honorable Chair, the provision as proposed by government is that for you to register, you provide a copy of the Constitution specifying the objects of the society as specified in Section 57. To ask them to provide a copy of the articles and rules of the collecting society, a copy of the certificate of incorporation as a company limited by a guarantee without share capital by registry of companies is duplicity. The moment they are registered and they have their constitution, let us allow them to take the form that they wish to take, depending on the circumstances of their business. So, Right Honorable Speaker, Right Honorable Chair, I propose that Clause 20 stands as part of the bill without the amendment as proposed by the committee. I beg to submit.
Chair.
Madam Chair, this morning, while interacting with some members of the creatives in our consultation, this matter came up, although we didn't discuss it thoroughly. I had an opportunity to discuss it further with some of the members. And their ideas seemed to be in line with what the Attorney General has just said. Number one, that having two collective management organizations in one band of rights. For example, if you had, for the musicians, if you had the UPRS and then there's another one, it would be an extra cost to the entities.
Why do you take long to? Please.
So, the speaker is accusing me of taking long to finish. So the short of it is that the Attorney General, the proposals are in line with the creatives that we had this morning discussing this matter, and I concede.
I put a question that Clause 20 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 21.
Chair.
Madam Chair, Clause 21, the committee has a proposal to amend Clause 21 in paragraph C by inserting immediately after the proposed paragraph BA the following. BB. In consultation with its members to prescribe fees for accessing corporate works owned by its members. Justification to enable collection societies set fees for accessing corporate works owned by its members.
AG.
Right Honorable Speaker, Right Honorable Chair, we have no objection. That amendment, it enhances the proprietary rights of the members in those societies. I concede.
Thank you. I put a question that Clause 21 be amended as proposed. Those in favor stand the contrary nay. The ayes have it.
Clause 21 as amended.
I put a question that Clause 1 as amended stands part of the bill. Those in favor stand the contrary nay. The ayes have it.
Clause 22.
I put a question that Clause 22 stands part of the bill. Those in favor stand the contrary nay. The ayes have it.
Clause 23.
I put a question that Clause 23 stands part of the bill. Those in favor stand the contrary nay. The ayes have it.
Clause 24.
I put a question that Clause 24 stands part of the bill. Those in favor stand the contrary nay. Those in favor stand the contrary nay. The ayes have it.
Clause 25.
I put a question that Clause 25 stands part of the bill. Those in favor stand the contrary nay. The ayes have it.
Clause 26.
I put a question that Clause 26 stands part of the bill. Those in favor stand the contrary nay. The ayes have it.
Clause 27.
I put a question that clause 27 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 28.
I put a question that clause 28 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 29.
I put a question that clause 29 stands part of the bill. Those in favor say the contrary nay. You have even stopped talking. The ayes have it.
Clause 30.
I put a question that clause 30 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 31.
I put a question that clause 31 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Title.
Clause 1.
Clause 1.
Thank you, Madam Chair. Clause 1, the committee proposes amendments as follows. In paragraph A, 2, in the definition of broadcasting by inserting immediately before the word wireless, the word wire.
Chair, we will approve one by one. One definition at a time. Okay?
Thank you, Right Honorable Chair. Right Honorable Chair, in clause 1, there was a proposed amendment to accessible format, which the committee did not question.
To access what?
Accessible format, format
Okay.
copy.
Yes.
Then we have anonymous work. So the third one is the proposal.
And the third one, the proposal is in the definition of broadcasting by inserting immediately before the word wireless, the word wire or.
Right Honorable Speaker, Right Honorable Chair, we concede to that proposed amendment that wire or wireless widens the definition of broadcasting.
Those in favor say on the contrary nay. The ayes have it. Next.
In 3, in the definition of often works, by inserting immediately after the word found, the word or is unknown.
AG.
Right Honorable Speaker, we have no objection to that proposed amendment.
Those in favor say on the contrary nay. The ayes have it.
And in 3, Madam Chair, in the definition of sound recording, by inserting immediately after the word thereof, the words whether as stand-alone fixation or incorporated or used in other media after the initial fixation.
Right Honorable Speaker, sound recordings as provided in the bill as proposed by government are a distinct category of work protected by the copyright, and therefore the addition here distorts that meaning. We propose that the definition of sound recording as proposed by the government bill do stand as part of the bill.
I put a question that this stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Madam Chair, 4, in the definition of circumvent a technological protection measure by inserting the following phrase at the end of the provision, without the authority of the copyright owner.
AG.
Right Honorable Chair and members, we cannot possibly write a law to allow anyone to circumvent the law. So that even the owner cannot be allowed to circumvent the law. So I propose that the provision as stands in the bill does remain.
Chair, concede.
I think the Attorney General has been quite reasonable.
You want to circumvent?
You cannot allow anyone, including the owner, so I concede.
Okay, I put a question. Those in favor say on the contrary, nay. The ayes have it. AI, we drop it.
5 in is
AI
by,
is
by
a
inserting the
consequential.
definitions of by inserting the following definition in their appropriate order in the bill. AI, artificial intelligent works,
Drop.
means work generated by an artificial intelligence system through human creative input, direction, or supervision.
Drop it. It collapses. Drop.
The Attorney General will come and make a comment on it. Then
It collapses. It is consequential to the.
Consequential.
Yeah, it is consequential.
consequentially. The next one is collective society, means an organization approved and authorized by the Registrar of Copyright, which has its main object or one of the main objects, the negotiating for collection and distribution of royalties and the granting or licenses in respect of the use or copyright works or neighboring rights.
AJ.
Right Honourable Speaker and Honourable colleagues, the Act itself, the body of the Act already determines the object of a collecting society. It is in the body itself. So to define it here like this would conflict with the object already stated in the law. So I propose that this be dropped.
No harm, Madam Chair.
Thank you.
Because
Next. Next. Next.
the provision on AI.
Reprographic coffee.
Yeah, the provision on AI is dropped in the amendment, in the definition section.
So next definition. Is that all you have?
Right Honourable Speaker, there was a provision under the definition of derivative works to include works generated by artificial intelligence. That is also consequential amendment that is going to be dropped. It had been proposed by the committee. The committee also proposes a provision for training data set, means the data set including copyright works used to train an artificial intelligence model system. This again is a result of, as per the discussion we had in respect to AI as a tool, we propose that that provision also be dropped.
Okay.
Madam Chair, I missed that page in my report. Been looking for it, I could not see it, but the import of our definition was to make it clearer. So if it, in the view of the Attorney General, the matters are clear, I have no problem. I drop.
Thank you. I put a question that clause 1 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 1 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Motion for resumption of the House.
Honorable Minister.
Yes. Right Honorable Speaker, and honorable members, I beg to move that the House do resume and the Committee of the whole House do report thereto. I beg to move.
Thank you. I put a question that the House does resume and the Committee of the whole House reports there too. Those in favor say and the contrary nay. The ayes have it.
Report of the Committee of the whole House.
Honorable Minister.
Right, Honorable Speaker and honorable members, I beg to report that the Committee of the whole House has considered the Copyright and Neighboring Rights Amendment Bill 2025 and passed it with amendments. I beg to move.
Motion for adoption of the report of the Committee of the whole House.
Honorable Minister.
Right, Honorable Speaker and honorable members, I beg to move that the report from the Committee of the whole House be adopted.
I put a question that the report of the Committee of the whole House be adopted by this House. Those in favor say and the contrary nay. The ayes have it.
Bills, third reading. The Copyright and Neighboring Rights Amendment Bill 2025.
Honorable Minister.
Right, Honorable Speaker and honorable members, I beg to move that the bill entitled the Copyright and Neighboring Rights Amendment Bill 2025 be read for the third time and do pass.
I put a question that the Copyright and Neighboring Rights Amendment Bill 2025 be read the third time and do pass. Those in favor say the contrary nay. The ayes have it.
A bill for an act titled the Copyright and Neighboring Rights Amendment Act 2026.
Title settled and the bill passed. You can now say what you want to say.
Honorable Speaker, it's one of those times that I get to congratulate the House on passing a bill. This bill was incidentally initiated by we on the opposition side through our Shadow Minister for Arts, the Honorable Hilary Chiaga, who is part of the community. Government did take over the bill and the law does allow, and here we are. Let me say, you know, we pass many bills here, and normally the problem is implementation. So I have seen, and the artists are very excited that the bill has been passed. We are all excited that the bill has been passed. But I hope we are not going to have run-ins when it comes to implementation. That's normally the problem. So the bills gather dust and they're not acted upon. And then the excitement ends up fading. I hope we don't get to that point. That said, Honorable Speaker, the old law of 2006 had regulations of 2010 that came through in 2010. We hope that there will be new regulations to actualize, because now this is an amended bill, so we cannot rely on the 2010 regulations. We hope that there will be regulations that will come through to harmonize and actualize some of the things, because there was still some pettifogging over some clauses and so on, but the regulations help to remedy that. I hope that they will come through soon enough so that then actualizing of this new law gets to happen. With your permission, Right Honourable Speaker, kindly allow a 30-second comment from the Shadow Minister for Arts, who is the initial initiator of this bill.
Honourable.
And he's also part of the community. With your permission, Right Honourable
Honorable.
No, I've already mentioned we initiated and government took over.
Honorable Law, please sit. First of all, I want to thank all the members of Parliament for passing this very important law. I also want to thank you, Honorable Hillary, for the first initiation. I want to thank government for ensuring that the bill came to the House. I want to thank, in a very special way, the Attorney General. I also want to thank the committee for the good work you've done. I also want to thank our stakeholders for being here and following up the law. I want to thank, Kavanda, you said I thank you. Okay, I want to thank Honorable Kavanda and myself. But in a special way, I want to thank all the members of Parliament. And one thing I want to tell our good friends there was no ill emotion, no ill motive on delaying the bill. Now the bill has passed. So will you continue making noise out there? You can now go and make noise that the bill has passed. And we are not ignorant. We have students and teachers from Science High School, Mukono Municipality. You're most welcome. They are here to witness the proceedings. They are represented by Honorable Betty Namboze and Honorable Nabukera and Ifa. Most welcome, and thank you so much for coming. The house is Adijant Sandine.